Oh, hello. Well, hello and welcome. Oh, I think my lighting's bad. I cannot get this right. One day I'll get it right and you'll all be so shocked. You'll wonder what on earth is wrong with me. How are you all going? I hope you've had a good day / night. Hello, Mr. Obvious. Wow, I have had Friendlyjordies comment on my video, my last video about the call update, thanking me for my support and keeping up the good work. So I've had a moment. I've just got to I got the vapors. No. I mean, what do you do when somebody of Friendlyjordies size says, hey, thanks for the support. You're doing a great job. What do you say? Me? I go, thank you. Now, just excuse me while I go have a moment. Really? That's what you say? That's what I said. Oh, dear me. What a dork, hey? What a dork. What a dork. Oh. So, yeah, it was. Let me just grab it and I'll get it up for you so you can have a look. Yeah, I looked at it and I went, is it really? And it was like, yeah. So we're going to start off with the Friendlyjordies stuff, the court case, because there's a lot in there. Here we go. Look at this. And we're going to end up as far as I know, there's been nothing filed, but with Katie Joy, but she's poking the bear. She says, thanks so much for the coverage, Joanne. You're doing a great job. And I said, thank you. Now excuse me while I have a moment. That's what I responded with. Oh, dear me. Like, hello. I should have said, I should have written, well, thank you. I hope you've subscribed. The woulda, shoulda, coulda. I'm sure it's Osbel's artwork that would have attracted him. Thank you, Short of the Cook. John Green says I'd have 3 seconds to be composed before dissolving into a screaming, cackling puddle of incoherence. Well, I must say that if you actually have a look, I did it about 10 minutes ago, and I've and then and I've got to give you an update with Harrison, because that became a really big mess, but he's okay. He's happy now. He gets to spend his birthday with his dad, but his dad gave him his present beforehand thinking he wasn't going to be around, and I said to him, I said, are you going to give it back to your dad to wrap up again? He said, no, thank you, Plan to Create. Yeah, I'm very, very, very happy. It's good to be noticed, because but I'm just happy that people are watching, really. That video, I think, has got 1,000 views so far, and it's only been up since, I think I did about 11 o'clock. So it's only, yeah. The Jordan, the call update ones really do really well. Yeah. The Department of Health apologised for there was a mistake made. They called the Coles a tier 1 when it shouldn't have been. But as I said, my brother works in hotel quarantine, and he's actually tested every single day. Even if he has the day off, he has to go get tested. So we, and he even rang the health department. They told him not to worry, and then it was well, we're going to have to, you're going to have to isolate. So, and then, so they went home, kids went home, and then they came back again. So he's very happy. Anyway, I think I've got another 10. I think I'm sitting on 2,093. So I'm 7 away from 2.1. So that's pretty cool. All right. So let's start off with the Barilaro and Shanks. So let's look at Twitter first. We'll go with the lighter stuff first, and then we'll get into the heavier stuff. There's the judgment from Justice Rares, and then the orders that he made. So they're back at, essentially, the summary is they're back at court on the 31st of August. Shanks has to refile his defence, and Google have to file their defence. Now, the only thing is, I think Google, from what I can work out, they're not going to, they're prepared to pull analytics and everything. I know that Brazz's lawyer implied that Google and Shanks had earned thousands and thousands of dollars from the videos, and I think it's also very clear to realise that they have no idea how the analytics go. Yeah, John, it is a very vile process. When I was working in hotel quarantine, we had to have saliva tests every day, and then once every 7 days, we had to have the swab. So Google is going to back Shanks for a jury trial at this stage. They also said, where's my notes? Qualified truth, I think they said. They were going to, yeah. But essentially, because of the parliamentary privilege issue, implied truth is now off the table. You can't say, so if a member of parliament says something in parliament and you call them a liar and you sue them for defamation, or they sue you for defamation, you can't say the fact that they've lied and prove that they've lied in parliament to defend yourself, which is really bizarre. Now he can choose. I mean, if he really wants to, he could appeal, but I mean that's going to cost money. The other thing is, I noticed that Braz's lawyer was really keen. She wants this done. They want this done really expediently. But so Michael West, right? So the Friendlyjordies defensive truth has been ruled out. So we can't put John Barilaro, who has bought the claim, in the witness box, but can still argue the corrupt conman imputation. Bad thing is you can't defend yourself against what politicians say in Parliament. Apparently, they can say anything about you, and you can't sue under this judgment from J. Rares. Good thing is for both truth, public interest, and Friendlyjordies Google has turned up and said they will defend the claim, not bury it for a few dollars, but stand on principle. That is big. That is big. So they're prepared to stand on it. So can you argue truth in court? YouTuber Jordan Shanks has just been told he can't present a defense of truth in the Barilaro case. So the defense of truth under parliamentary privilege, you can't have anymore. Oops. So Shanks said, where was it? He had something here, 7 hours ago. Quite strange. It appears if you criticise what a politician says in Parliament, they can sue you for defamation and you'll be denied a chance to defend it, as defending it would breach parliamentary privilege. This could make politicians a lot of money. So then we go up here, and Justin Field, the Independent, New South Wales, says, we have a problem. If a member of the public calls out a mistruth by an MP in Parliament, and they can be sued for defamation by that MP, but can't use what the MP said in Parliament as part of their defence. That's essentially what has been ruled. So it is a problem. So Barilaro, a ruling against us today, re perjury. In effect, parliamentary privilege denies Shanks the ability to run the truth defence in the action brought against him by John Barilaro. Denied a truth defence. We are considering our legal options. Stand by. Now, they may actually choose to appeal it and say that he was wrong, but there would have to be legal argument as to why they were wrong. You just can't say we're appealing because we think the judge is wrong. You actually have to find stuff within the law as to why it was wrong. Here's another. Mr. Shanks can ask Parliament to waive its privilege if he wishes. So that's the other thing he can do. On the upside, truth is available to defend the corrupt conman imputation. Justice Rares says the improper use of ministerial power to benefit a political party or donor is capable of being understood by the ordinary reasonable viewer as corrupt. So we might look at I haven't looked at the Guardian, so let's look at the Guardian article, and then we'll look at the all the court stuff. We'll go to the hard stuff. So it says Jordan Shanks loses preliminary fight in John Barilaro defamation case. Now remember, sometimes you have to lose the battle to win the war. I think this is just a minor setback. Really? I don't want to. Do I have to? Oh, this is the Sydney Morning Herald. I don't want the Sydney Morning Herald. So, I can't view it. I thought it was the Guardian. I thought it was something. I thought it was a free one. Let me just see if the Guardian's got it. Well, I just find it very bizarre. Oh, here we go. I find it very bizarre that, so essentially politicians can't be called for account for what they say in Parliament, essentially. So here we go from the Guardian. Wrong button. Oh, look at that yellow. All right, I've read 7 articles in the last year. They're all probably about Shanks too. All right, YouTube personality Jordan Shanks has suffered a blow in court with Sydney judge refusing to strike out part of a defamation case brought against the entertainer by New South Wales Deputy Premier John Barilaro. The application by Shanks, who uses the non-diplom Friendlyjordies in his popular videos, related to Barilaro's claim that the YouTuber defamed him by claiming he committed perjury 9 times and should be jailed for it. Lawyers for Shanks argued he wouldn't receive a fair trial because his defence would breach parliamentary privilege. The alleged perjury is said to have happened at a parliamentary committee. Barilaro is suing Shanks and Google, who owns YouTube, over 2 videos titled Bruz and Secret Dictatorship, published in September and October 2020. Barilaro alleges both videos portray him as acting corruptly. I won't go there. Your Congress would love that, right? I bet you there's a lot of politicians rubbing their hands together with this ruling. Shanks wanted to argue that the imputation that Barilaro committed perjury 9 times was substantially true, and that the imputation he deserved to be jailed for that was his honest opinion relating to a matter of public interest. The public interest was said to be what Barilaro said in the 2018 evidence to a committee of the New South Wales Legislative Council and was based on his evidence. It was his own evidence. But in the federal court on Friday, Justice Stephen Rares refused to stay the case in relation to the 2 imputations. Mr. Shanks recognised that unless the New South Wales Parliament waives parliamentary privilege, he cannot impeach or question what Mr. Barilaro said in his evidence to the committee. The judge said, in concluding that the proposed offences would breach parliamentary privilege, the judge said he could not be allowed to rely on them at the present time or until parliamentary privilege was waived. The question arises whether it is fair that Mr. Barilaro can still rely on these 2 imputations, even though Mr. Shanks has no defence to them that he can rely on in this court. The judge said Shanks chose the way in which he published the Bruz video, which appeared to have been scripted and produced with considerable technical skills and supports. It was not a spontaneous or unprepared publication, and he was not responding to an attack made by Barilaro on him under parliamentary privilege. Which are interesting. So if you get attacked under parliamentary privilege, apparently you can rant and rave and call them whatever, and that would be all right. But because it was scripted, they're saying that. Rather than being unfair that parliamentary privilege prevented him from relying on his defences, the judge said it would be unfair to deprive Barilaro of the right to vindicate his reputation that Shanks attacked. It would be an affront to justice if a publisher could choose to question or impeach proceedings in Parliament and by doing so create for themselves an effective immunity from suit by a member or persons attacked. Such a result would convert parliamentary privilege into an instrument of oppression. The judge allowed Shanks 14 days to file a new defence. At a later date, the judge will hear an application by Shanks for the ultimate hearing to be held before a jury rather than a judge. So that's the Guardian's update. Actually, I don't think I was bad off, actually. I don't think my summary was that far off. Yeah. No, there's been no mention of the improper use of the fixated persons unit. Nothing. Hey, Laura. Oh, I'd love to be Governor General too. I know what I'd be doing. I'd be kicking them out. Oh, dear. Anyway. So that's some of the media stuff around that. So I did do a retweet today, again, of Shanks. It says, this is our parliament, or is it their parliament? Well, this is my problem, Short Order Cook. Why can't we hold them accountable? He says, Barilaro's barrister, Sue Chrysanthu, SC, just made the incredible misleading claim that the 2 videos Barilaro is suing over are raking in heaps of ad revenue for both Google and myself. I doubt they would have made enough to even pay Sue for 30 minutes of her time. It's true. Like, I think, what is it? 10 cents per 1,000 views or something like it's something really ridiculous. Is it $1 per 10? I don't know. You know, it's So anyway, so let's have a look. Let's look at this is the judgment. So let's look at the judgment, and it's going to be full of all, court words. But this will show you, we'll just have a look how it's laid out. Then we'll look at the orders, but the dates and everything for the other part of because the 27th, the 23rd of August, the new defences have to be filed, and they're back in court on the 31st of August. So this is the decision, the judgment of RARES. So it's constitutional law, parliamentary privilege. The application to strike out or stay part of the proceedings. Whether particulars could support proposed defence of justification. Application for leave to file and serve defence at a time. So he granted the leave. He didn't rule on parliamentary privilege. He didn't strike out. I think he struck out one of the parts, but not two. Oh, he says held. Publisher entitled to plead defences. Publisher not entitled to plead defences that would infringe parliamentary privilege. Held. Stay or strike out proceedings in relation to imputations refused. If defences capable of proper pleading, publisher must reformulate contextual imputations of particulars and justification and honest opinion defences and practice and procedure. Publisher given leave to file and serve reformulated defence within 12 days. So that's essentially how that worked out. You get the long version. So this is all the constitution, all the acts, all the law, all the cases. Oh, look, cases cited, Barilaro V Shanks. He's got his own little bit now. So there's 157 paragraphs to this, and this is the hearing on the 23rd of July. So this is the hearing. This was the matter or the day that they appeared that Shanks has to pay for now. Look, they are, if they can find that he's made a mistake in law, an error in law, they can appeal it. But they would have to, they have to find, and they would have to find an error in the law. I have no doubt that there are people now reading this thoroughly. I thought this said with Mr. Bean. All right. And the second, and remember, Google wasn't at this point here. This was when Google was given authority to be served. All right. So this says the first respondent's proposed defences that imputation 9B was a matter of substantial truth and imputation 9C was his honest opinion relating to a matter of public interest based on proper material within the meaning of SS 25 and 31 of the Defamation Act of 2005 would amount to questioning or impeaching proceedings in Parliament in a contravention of Art 9 of the Bill of Rights 1688 in England. That is the law of the Bill of Rights 1688. We still are using English law for some parts. I was quite fascinated by that. All right. So the first respondent have leave to file and serve on or before the 25th of August 2021 a defence in the form lodged for filing on the 7th of July, subject to admitting the defence of justification of imputation 9B, so they can't plead 9B, admitting the defence that imputation 9C was the first respondent's honest answer, they can't use that, deleting and, if possible, repleting each of the contextual imputations 21A, B, C, D, E, and F so that it alleges an act or condition defamatory of the applicant. Deleting and, if possible, repleting the particulars in Schedule A of the proposed defence to identify with precision and in accordance with Part 16 of the Federal Court Rules 2011 the facts and matters on which he relies as particulars of substantial truth. So you can use substantial truth. Proper material within the meaning of S31.5 of the Defamation Act New South Wales, and identifying under which paragraph of 31 the material falls. So they've got to state which act, which part, where the defence falls. So, and they've got to give a lot more detail. Identify in each matter complained of the statements relevant to the defence of honest opinion that he alleges are facts or proper material, expressions of opinion, and admitting any defences of imputations 9A, D, 15A, 15B, for which proper particulars consistent with the court's reasons for judgment delivered today cannot be given. The first respondent pay the applicant's cost of the hearing on the 23rd of July 2021 of paragraphs 1 and 2 of the interlocutory application filed on the 16th of July. So he has to pay the costs. So now he's got the introduction. So that was his order. And then here we've got all the pleadings. And he called it the Bros video, the Bros. So it says the first respondent, known as Joanne Shanks, seek orders in his interlocutory application filed on the 16th of July 2020 that he have leave to file his defence in the form lodged with the court 6 days after it was due to be filed under R1632 of the Federal Court Rules. Imputations 9B and C of the statement of claim filed on the 27th of May 2021 be struck out as an abusive process of the court under R1621, and the proceeding be tried by jury pursuant to S40 of the Federal Court of Australia 1976. So this one has not been determined. The jury trial has not been determined, but Google has actually said that they will support a jury trial. And Justice Reyes said it is very extremely rare to have a jury trial in a civil matter, and that he would like everything to be done as quickly as possible. So he's actually asking for submissions to be filed, to be worked on now, and so that because the particularly if the lockdown continues, and if they can go by jury trial, the time that it's going to take to put the jury together is actually going to take the longest amount of time. So, well, that's hello, Jenna Sweet Tea. Hello, Jen Hack. How are you? So the applicant, the Honourable, why do they have to call them Honourable? John Barilaro MP is the Deputy Premier of the State of New South Wales. He opposes the leave and strikeout applications. The statement of claim pleads that, and Mr. Shanks admit that he published 2 matters complained of, being YouTube videos. The first titled Bruz. Just as rare, it's titled Bruz, not Bros. First published on or about the 14th of September 2020, the Bruz video. And the second, entitled Secret Dictatorship, was first published on or about the 21st of October 2020. It's the Secret Dictatorship video. Mr. Barilaro's solicitor, Paul Sylvanus, deposed that as the 21st of July 2021, that there were over 756,000 views of the Bruz video, an increase of 121 since the proceedings commenced on the 27th of May, and over 384,000 views of the Secret Dictator video, an increase of over 43,000 since the proceedings commenced. So if he had, the thing is, right, if Bruz hadn't sued Shanks, the views might not have gone up so much. Let's be honest here. Let's call it. The fact that they went up so much is because people wanted to see what was said. Because anyway, I digress. The basis of the strikeout application is that Barilaro pleaded, and Mr. Shanks admits, that the Bruz video conveyed imputations that Mr. Barilaro committed perjury 9 times, imputation 9B, and so conducted himself in committing perjury 9 times, that he should be jailed, imputation 9C. I've attached a transcript of the Bruz video to these reasons as Annexure A, and will refer to the numbered paragraphs of the transcript where relevant below. Yes, there is a transcript of the video. Mr. Shanks says in the Bruz video that Mr. Barilaro committed perjury 9 times, telling the New South Wales Parliament that he did not personally sign off on a deal to give taxpayers money to a company run by his friend. Bruz video paras 74 to 78. Mr. Shanks argues that he would infringe parliamentary privilege under Art 9 of the Bill of Rights, 1688 England, if he pleaded or sought to prove justification of imputations 9b, or that based on its substantial truth, 9c was his honest opinion, and he would otherwise seek to do so. So remember, B, and so he can't use substantial truth, or he can't use honest opinion. I don't know, short order cook. Apparently, Justice Rares did say they would have to work something out. However, it would be, it's so rare for a jury trial. No, they didn't play the video in court. It was a shame because I would have loved to have seen it. Mr. Shanks admits that this impediment would make the trial of issues on those two imputations unfair because parliamentary privilege would preclude his proving, as he would wish to do, that Mr. Barilaro in fact committed perjury on 9 occasions. No mercy for stooges like Braz. Mr. Barilaro, on the other hand, opposes the strikeout application because of what he says would be unfairness of Mr. Shanks being able to make those serious defamatory statements with impunity by using parliamentary privilege as a shield. Hang on a minute. The pollies use parliamentary privilege as a shield. Why can't everybody else? I'm just saying. Mr. Barilaro argues that the defence has numerous pleading defects that would be struck out or require repleading if Mr. Shanks were allowed to file the pleading issues, and that Mr. Shanks' explanation for his default in filing the defence is inadequate. So Shanks had said the reason why it was late was that Christo got arrested. The issue of whether the pleading proceeding ought to be by jury cannot be considered now because of the second respondent, Google, has yet to appear after I granted Mr. Barilaro to leave to serve in the United States of America, Barilaro versus Sheikh Markovina. In these reasons, I found that there was sufficient evidence to suggest that Mr. Barilaro will be able to prove at trial that Google published and continued to publish these two matters complained of through making them available or downloading on YouTube website that it administers and operated. So he's saying that they had to seek leave, they had to get leave to serve Google, which they did. It is convenient to deal with the parliamentary privilege issue, which is the basis of the strikeout application first, before dealing with pleading issues and leave application. Okay, so now we're going to get to the thing about legislation and everything. It's where he's talking about the legislation, interpretation of legislation, and interpretation of law is where, if they're going to appeal, they can do. Article 9 of the Bill of Rights applies to the Parliament of New South Wales by force of S7 of the Imperial Acts Application Act 1969, which preserves the continuing effect as set out in modern English in the third schedule to the Act. One of the grievances that the House of Parliament recited against James II was, really? James II? Really? Oh, James II. Porter went on mental health leave. Didn't Matt Lanning go on mental health leave? I don't know where the brothers. By the assistance of divers, evil counsellors, judges and ministers employed by him, did endeavour to subvert or extirpate the Protestant religion and the laws and liberties of this kingdom. By prosecutions in the Court of King's Bench for matters that causes cognizable only in Parliament, and by the divers, other arbitrary and illegal courses. Emphasis added. The House has then declared in Art 9 the foundation of absolute privilege, known as parliamentary privilege, as followed. For the vindicating and asserting their ancient rights and liberties declare, the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or placed out of Parliament. Relevantly, the Defamation Act in 2005, New South Wales, provided at the dates the first publications of the Braz and the secret dictatorship videos. Single course of action for multiple defamatory imputations in the same matter. A person has a single course of action for defamation in relation to a publication of defamatory matter about a person, even if more than one defamatory imputation about the person is carried by the matter. Defensive justification is the defense to the publication of defamatory matter if the defendant proves that the defamatory imputations carried by the matter of whether plaintiff companies are substantially true. Defense of contextual truth, it is the defense of the publication of defamatory matter if the defendant proves that the matter carried in addition to the defamatory imputations of which the plaintiff claims one or more other imputations that are substantially true. Remember, this is all the law stuff here. The defamatory imputations do no further harm to the reputation of the plaintiff because of the substantial truth of the contextual imputations. To me, I was going to say this doesn't do any harm. This 26B, I don't think the imputation of him being a corrupt con man does him any trouble because he's gone on and saying about barreling. Hello, Cal. Defences of honest opinion. In defence of publication of defamatory matter, if the defendant proves that the matter was an expression of opinion of the defendant rather than a statement of fact, and the opinion related to a matter of public interest, and the opinion is based on proper material. That's what Shanks has to prove. For the purposes of this section, an opinion is based on proper material. It is based on material that is substantially true or was published on an occasion of absolute or qualified privilege, was published on an occasion that attracted the protection of the defence under this section or section 28 or 29. But they can't use the proper material, which is parliamentary privilege. So they've really just, they've been put into a bit of a tight spot. As Beaumont J explained in Arm Aviation Proprietary Limited during Commonwealth versus Commonwealth of Australia in 1988, the Parliament of Commonwealth enacted the Parliamentary Privileges Act 1987 to overturn interpretations in the Supreme Court of New South Wales of Art 9 in two trials of Justice Lionel Murphy. Then there's Linehelm versus Hanson Young, and relevantly parliamentary. So he actually was the judge in the Hanson. Interestingly enough, he was the judge in the Hanson Young David Linehelm defamation, where Hanson Young won, and Chrysanthi was the lawyer. That's just an aside, but anyway. Relevantly, the Parliamentary Section 16.3 of the Parliamentary Privilege Act provides, in proceedings in any court or tribunal, it is not lawful for evidence to be tendered or received, questions asked, or statements, submissions, or comments made concerning proceedings in Parliament by way of or for the purpose of questioning or relying on truth, motive, intention, or good faith, or anything forming part of those proceedings in Parliament. Otherwise, question establishing the credibility, motive, intention, or good faith of any person, or drawing or inviting the drawing of inferences or conclusions wholly or partly anything forming part of those proceedings in Parliament. And that is what he's upholding. Essentially, what happens in Parliament is untouchable. Well, I would have thought that too. I guess that's where they're going to go, because he did, and don't forget what his lawyer, Sue Chrysanthi said, it's not corruption if you're caring for your community. Yeah, that's what his lawyer said. So I would be quoting his lawyer. Oh, thank you, Graham. I have actually just applied for the Juris Doctor degree for next year, because I can't do another bachelor. I have to do a master's level, and that's the law degree in master's level. But thank you, Graham. I just need to get in. But thank you. All right. So, and the thing is, what has helped me is I was in the court today. Like, I was watching on Teams, Microsoft Teams today when this was going down. So I sort of was there and making notes. So Mr. Barilaro pleads that the Bruz video, in its natural and ordinary meaning, contained the following 5 imputations or imputations that do not differ in substance. When I refer to imputations in the reasons, I intend to include the ones that do not differ from them in substance that were defamatory of him. So this is what Bruz says upset him. Hello, the fox. Mr. Barilaro is a corrupt con man. Mr. Barilaro committed perjury 9 times. Mr. Barilaro has so conducted himself in committing perjury 9 times that he should be jailed. Mr. Barilaro corruptly gave $3.3 million to a beef company. Mr. Barilaro corruptedly voted against the Royal Commission into water theft. Mr. Barilaro pleads that the secret dictatorship video, in its natural and ordinary meaning, contained the following 3 imputations that were defamatory of him. QC. No way. Oh no. So this is from the secret dictatorship video. This is what he got offended by. Mr. Barilaro has acted corruptly by engaging in blackmailing of councillors. Mr. Barilaro has acted corruptly by engaging in the blackmailing of councillors using taxpayers' money. Mr. Barilaro has pocketed millions of dollars which have been stolen from the Narrandera Shire Council. In his defence, Mr. Shanks admits that he published the Bruz video of and concerning Mr. Barilaro, admits the Bruz video conveyed imputations of 9A, 9B, 9C, and that they were defamatory of Mr. Barilaro, denies that the Bruz video conveyed imputations 9D and E, but admits that if either were conveyed, it was defamatory admits that if they were conveyed, it was defamatory. Pleads a defence under S25 of the Defamation Act that each of the imputations 9A and B is substantially true and provides the following particulars. So I think A and B, and I don't have it in front of me, I think one of those relates to parliamentary privilege. So that's where we're going. Such particulars as Shanks is presently able to give respect to imputation 9A are set out in the schedule. The balance of particulars, the particulars on which Shanks seeks to rely in respect of imputation 9A and in particulars respect of imputation 9B cannot be given unless the applicant and the New South Wales Legislative Council waive parliamentary privilege in respect to statements. Yes, so 9A and 9B were about what was said in Parliament. Pleads a defence under S26 of the Act that the Bruz video also conveyed the following contextual imputations. The applicant blamed the National Parks and Wildlife Service of New South Wales for the bushfires that destroyed the state in late 2019 and early 2020 by accusing the NPWS of neglecting its responsibilities for conducting bushfires and having supported cutting funding to the NPWS by 27%, the number of rangers by 100, and the number of people who make plans for hazard reduction burns by 36 to 10. The applicant falsely accused the NPWS of next responsibilities for conducting controlled hazard burns on ideological grounds, thereby exacerbating the bushfires that devastated New South Wales in late 2019 and early 2020, when he knew that the reason controlled hazard burns had not been conducted was the cuts his government had made to funding the NPWS. Well, so they're saying that this is defamatory. Okay, this is what Bruz is saying is defamatory. That's essentially what the judge is saying. While the catastrophic bushfires that devastated regional New South Wales in late 2019 and 2020 were raging, the applicant decided to continue his holidays in London rather than return to the state to assist in managing the response to fires. Wasn't ScoMo in Hawaii at that time? What is it with these pollies and overseas trips? What is it with these pollies and overseas trips? We had the Prime Minister in Hawaii and the Deputy Premier of New South Wales in London. So is he denying? Is Bruz saying he wasn't in London? Well, the applicant is a hypocrite in that, having publicly stated that he supported a Royal Commission into water corruption, he voted against the motion moved by the New South Wales Parliament to establish such a water commission. Again, would you? I don't know that you could use the votes. That was in that that stuff that was put in Parliament. So I wonder if that's under parliamentary privilege. The applicant opposed the coloured wild horses in the Kosciuszko National Park, despite well knowing that the horses were causing severe damage to tens of thousands of hectares of wilderness and pushing some 27 native species to the brink of extinction. The applicant championed legislation to protect wild horses in Kosciuszko National Park from being culled, despite knowing the damage that they were doing, were causing tens of thousands of hectares of wilderness and some 27 native species. That the New Parks Wildlife Service, NPWS, and scientists had proposed the cull without declaring, in accordance with his legal obligations, that he had received $10,000 in donations from a donor who had an interest in the passage of the legislation, and that the applicant breached his obligations as a member of Parliament by failing to disclose in the register interests that he earned substantial income from his massive estate that he owns and rents out via platforms such as Airbnb and Stays. Pleads that the contextual imputations are in addition to those which Mr. Barilaro complains and are substantially true, and because of the substantial truth of the contextual implications, those of which Mr. Barilaro complains, to the extent that they are admitted, were found to be conveyed by the Bruz video, do not further harm his reputation. So that's what he's saying. He's saying contextual truth doesn't matter because his reputation is not going to be harmed. Please the defence under S31 the Act that each of the imputations 9A and C, and if either are both found to have been conveyed 9 and D, and as expression is the Shanks' opinion that related to matter of public interest and was based on proper material, and the proper material, that's the same. And again, parliamentary privilege is required. Admits that he published the secret dictatorship video, denies that it conveyed any imputations, but admits that if any was conveyed, it was defamatory. So they always say that it be published it, but hey, it may be. Pleads the defence under S31 of the Act that if either imputations were conveyed by secret dictatorship, it was an expression of Mr. Shanks' opinion that related to matter of public interest and was based on proper material, particulars of which were set out in Schedule A of the defence. Pleads that if he's found liable, he will rely in mitigation of damages on such imputations 9A and B, and the contextual implications are found to be substantially true, and the facts, matters, circumstances he proves in support of his pleaded defence. Schedule A of the defence contains 79 paragraphs as particulars of defences to the Bruz video and to the secret dictatorship video. On the 16th of July 2021, Mr. Shanks' solicitor by letter provided Mr. Barilaro with particulars of the matter that he alleged was subject to parliamentary privilege. So, essentially, he can't rely on anything that requires a breach of parliamentary privilege unless Shanks can write to the New South Wales Parliament and request parliamentary privilege. That's the only way that he can plead those defences. But he can't ask Bruz to do it. Mr. Shanks argued that it would be an abusive process to allow Mr. Barilaro to rely on parliamentary privilege. That was Mr. Shanks contended as a result of his inability. That's a discussion for another night. He wished to be able to prove that Mr. Barilaro had appeared before a parliamentary committee of the New South Wales Parliament, the Portfolio Committee 3, Education of the Legislative Council, and committed perjury on the alleged offence. He submitted that unless Mr. Barilaro somehow caused Parliament privilege to be waived in respect of his giving evidence before the committee, including by obtaining an Act of Parliament authorising this to occur, Mr. Shanks would be in an unfair position. That was because Mr. Shanks argued that Mr. Barilaro would be able to recover damages in respect of the admissions in the defence that the imputations on B and C were conveyed and defamatory when, had he been able to defend them, he may have been able to make out his defences. Mr. Shanks asserted, but for the operation of Art 9, he would be able to lead evidence which would prove the basis for the defences. So Shanks was saying that if we could get parliamentary privilege, we can prove that what we were saying was true. Mr. Shanks argued that R1621 enabled the court to strike out a pleading or stay a part of the proceedings where the pleading or part of the proceeding would otherwise be an abuse of the court's process. He contended that to allow Mr. Barilaro to proceed on the imputations 9B and C without a waiver of parliamentary privilege would result in the manifest unfairness relying on, among other authorities, Walton and Gardner. Mr. Shanks admitted that although rare, there are circumstances in which defamation claim may be stayed where a publisher is unable to rely on or prove a defence because Art 9 would preclude him from impugning or calling into question the truth of statements made under parliamentary privilege. He argued that his was such a case relying in particular Wright versus Lewis, and that's a one television New Zealand, Rand versus Paulson. Mr. Shanks contended that his case was on all fours with Wright. He noted that although the Privy Council found the full court in Wright had wrongly decided that construction of Art 9 had erred in that respect, it would probably have granted a stay. So there's some more laws there. Mr. Shanks contended that the situation fell within their lordship's description in Preble for extreme circumstances that would preclude the fair determination of issues between parties and thus created the need for the stay of proceedings on imputations 9B and C unless and until parliamentary privilege was waived. He submitted to find otherwise would be to discourage free reporting on members of parliament or others who had told falsehoods during parliamentary proceedings because a publisher sued by that parliamentarian or other persons would always be barred by absolute privilege afforded by Art 9 or Parliamentary Privileges Act from being in the defence of substantial truth or proper material for defence of honest opinion where the defence would otherwise be available. So he's saying, so what they're saying there is, and it's really here, that it would discourage free reporting on members of parliament who told falsehoods during parliamentary proceedings because the parliamentarian could sue them and they'd have no defence. That was essentially the defence. So now he's looking at the parliamentary privilege issue and we're going, I'll just skip some of that if that's okay. Because now he talks about sort of summarizes. But if this is where it's this interpretation that if they're going to get an appeal, they will need to appeal. So if he reads this and he quotes it and they believe that he has misinterpreted it, the law, they would be able to, they have to find a mistake. They have to argue on law. It can't be common sense. It has to be in law. There has to be something in law. So the Defamation Act and its analogies equally reflect these fundamental values that underpin the free flow of information, comments, opinions, and arguments that are necessary to the effective functioning of a parliamentary democracy. Thus, a publisher can avail himself, herself, or itself of the statutory defences of the Acts, provides including a fair reporting of proceedings of public concern. That is what we're allowed to do for the court. So although you can't record it, you can't video it, you're allowed to take notes for fair report of proceedings. I don't know whether parliamentary privilege covers documents. Qualified privilege where the publisher proves that the recipient has an actual or apparent interest in receiving information on some subject. The matter is published to the recipient in the course of giving him, her, or it information on that subject. The publisher's conduct in publishing that material. These one circumstances, honest opinion that relates to matters of public interest and based on proper material. I always thought so that too. But I always thought that was right as well. But the public interest reflected in Art 9 ensures that the proceedings in Parliament are not actionable outside the House in which they occur. This protection exists so that persons, including witnesses before committees, can speak freely in Parliament or committees. Nonetheless, well, that's interesting. Yes, because they actually wanted to get the Hansard. They wanted to actually submit the Hansard, and you can't under parliamentary privilege, apparently, in a court of law. So essentially, you are, Well, and this is what I don't understand, because wasn't Lionhelm sued by Hanson Young for something he said in Parliament? Then why didn't that come under parliamentary privilege? Because I thought parliamentary privilege, you could get away, you could say whatever you liked. Anyway, I can't remember. It says the protection exists so persons including, so it's there to protect witnesses that are calling on committees. Nonetheless, the common law statutes, including the Defamation Act and the constitutional freedom, recognise a concomitant information or arguments in respect of them that, although apparently defamatory of a person who made the statement or was subject in the proceedings of Parliament, will not be actionable if made without the malice or if not unreasonable. The significance of the common law rights and defences established by the authorities, the constitutional freedom and the additional statutory defences is that the law has evolved balancing mechanisms that respect the strictures of Art 9, yet allow the victim of a public attack on him or her made under absolute privilege in proceedings in Parliament respond to the attack without being liable for defamation. There you go. Others who have an interest in or duty to discuss the subject matter can publish to the public at large a matter relating to or refuting the attack, and can also disseminate information, opinions, arguments about what is said or done in proceeding Parliament. As Adam and Lane show, a publisher has qualified privilege to denounce a statement made in Parliament as a falsehood in a matter that does not infringe Art 9 and does not attract liability for defamation. So essentially, Bruz can say whatever he likes in Parliament about Shanks. And if Shanks was then to respond, it would be okay. I hope you're all still with me. Is this boring you all, or is this very interesting? Please let me know. I can't make it any more interesting. I'm just trying to get this a bit more. So then there's another one. So in Wright, the plaintiff, a Liberal member of the South Australian Parliament, made a speech in the House of Assembly criticising, whoops, you're just following along? Oh, I'm a layman too, to be perfectly honest, Zesty. You find it all interesting? Yes, if Shanks was a member of Parliament, it would seem to be fine, Mr. Obvious. I think that's where we're going with this. I'm following intently. Okay, cool. So a Liberal member of the South Australian Parliament made a speech in the House of Assembly criticising as improper the obtaining of planning approval by a former secretary to a previous Labor Premier. The former secretary wrote a letter to the editor of the Advertiser, which published it. The plaintiff sued both the former secretary and the Advertiser as publishers. The defendants raised defences of qualified privilege, fair comment and justification. The District Court judge struck out all of the references to the parliamentary speech in the pleading of those defences, which is interesting because this is what I'm listening, but I'm listening while I'm trying to unblock my toilets. Oh, no! So we're talking about parliamentary privilege at the moment. So because even though Bruz has said some stuff that can be proven to be false or that he lied, it can't be used because it was done in Parliament. I have no idea what's happening with Christo. I cannot find anything about Christo. The full court of the Supreme Court of South Australia allowed the publishers' appeal. The Attorney General, on behalf of the South Australian Parliament and plaintiff, argued that the publishers could only prove as fact that the plaintiff made the speech in the House, but could not make any submission or inference about it at all by force of Art 9. So the District Court judge had been correct to strike out effectively all of the substantive defences of qualified privilege, fair comment and justification. And this is what essentially he's doing. The full court observed that if the argument were correct, there would be a gross distortion of the law of defamation in its application to a case where a member of Parliament sued in respect of criticism of what he or she had said in proceedings in Parliament. A lopsided and unfair contest that resulted in the defences of qualified privilege being substantially emasculated, justification being completely denied, fair comment not being able to include certain statements of fact, and damage being assessed on entirely artificial and false basis that no weight whatsoever can be given to the character or quality of what was said. Yes. To the attack. The defendants would necessarily be denied the opportunity of raising defences otherwise available by reference to general law. And that's, yes. And he can't refer to the Hansard where it's a bit, where it can be proven. Based on the law as explained above, in my opinion, the full court reasoning in Wright was erroneous in respect of the limitations that it found Art 9 imposed on the publishers that being able to conduct their defences of qualified privilege and fair comment. I am of the opinion the publishers in that case should have been able to conduct both of those defences. So the full court appears to have accepted the South Australian Parliament's view that the member's speech was admissible for the limited purpose of proving what was seen in Parliament as a fact, although it is not clear why, unless it was to support their ultimate conclusion that the publisher could defend using anything said in that speech for all purposes. So we've got some more here. We've got more. All right, we'll just scroll through here. What I'll do is I'll actually also put here's the link, and you can actually read. So if you want to read it as well, so that's the link to the judgment. So click on that and you can download it. So let's go. I'm of the opinion that this also represents the common law, provides proper material, includes material published on an occasion of absolute privilege, such as proceedings in Parliament. Here the question is whether and how Art 9 as a law of the state of New South Wales may apply to Mr. Shanks' proposed defences. So we've got here Mr. Shanks' proposed justification of impunity necessarily will involve impeaching or questioning in this court what Mr. Barilaro said in the proceedings of the committee. That is because that defence accuses him of committing perjury in these proceedings. I defined the defence of justification to what that imputation cannot be pleaded because it infringes Art 9. Had the defence been filed, I would have been bound to strike it out. And that's his reasoning. Yes, he needs evidence outside of the Parliament. He needs to prove, I guess, if he may, I mean, you're going to have to scour newspapers. Maybe he slipped up. I reject Mr. Barilaro's argument that there's no need to strike out such a defence and that it can be filed or remain on the record of the proceeding. The pleadings in a proceeding form part of the record of a superior court of record, such as this court. Moreover, once filed, a pleading in this court is published under absolute privilege that attaches to judicial proceedings, and any person who is not a party can expect a filed pleadings. The nature of absolute privilege of Art 9 and S16 established operates in an analogous way to that absolute privilege of those who make statements in the course of judicial proceedings, such as the members of a court, counsel, solicitors, and the use of the plea in the defence that Mr. Barilaro had perjured himself in the committee necessarily would be an impeachment or questioning of those proceedings. In Parliament in this court, and directly contrary to the injunction to prevent that occurring in Art 9. Mr. Shanks argued that the proposed defence of honest opinion in relation to imputation 9C equally relied on him being able to establish as a fact that Mr. Barilaro committed perjury 9 times in the proceedings before the committee as the foundation of his opinion, and that he should be jailed for his conduct. Mr. Shanks did not seek to defend imputation 9C as a whole as being an expression of his opinion. No doubt this was because the way in which the Bros video presented the statements and accompanying footage in paragraphs 72 to 78. Accordingly, the defence of honest opinion in relationship to imputation 9C also necessarily would involve impeaching or questioning procedure in parliamentary committee, contrary to Art 9, and therefore cannot be allowed to be pleaded. All right? Well, that's right. If there can be somewhere else where something's been said, I think they can use it. The question then arises as to whether Mr. Shanks is entitled to stay of proceedings in relation to imputations 9C. So now we're getting into the principles for stay. Must the court stay or strike out the claim because of parliamentary privilege? Waiver of public. I reject Mr. Shanks's argument that Mr. Barilaro has an onus to seek the New South Wales Parliament pass legislation waiving its privilege. The privilege is that of Parliament, not Mr. Barilaro. There is no reason why Mr. Shanks, who wants to raise a defence that will question or impeach the proceedings before the committee, should not put his case to Parliament to see whether its members consider it appropriate, if it is within their power to waive privilege, so that he can act in a way that would otherwise infringe Art 9. Secondly, Mr. Shanks chose the way in which he published the Bros video. He's admitted defamatory imputations 9B and C of and concerning Mr. Barilaro in respect to the proceedings in Parliament. Mr. Barilaro did nothing to contribute to Mr. Shanks' choice of what he published or how he expressed himself. Remember, if you're attacked in Parliament, you're able to defend yourself. So this line where he says, Mr. Barilaro did nothing to contribute to Mr. Shanks' choice of what he published or how he expressed it. So, however, I mean, I guess being offended, I guess the fact that Shanks is saying that Barilaro lied in Parliament isn't enough to say, isn't a contribution to him speaking out against it. It may be that legislation would be necessary for the waiver of Art 9, although neither Mr. Shanks nor Mr. Barilaro appears to have informed the presiding officers of each house or developed research submissions about the issue. So they have to write, without the hearing from the presiding officers or the Attorney General or having research submissions from the parties, it would not be appropriate for this court to express in any way about any limitations on the powers of Parliament. The next question is whether the preclusive effect of Art 9 on Mr. Shanks' ability to defend him would create an unfairness to the degree that Mr. Barilaro's right to pursue those elements of his claim should be stayed. Again, more court stuff. Unfairness, like fairness, is not an abstract concept. It must be evaluated in the light of all the circumstances. As Gleeson CJ said in Read Minister for Immigration and Multicultural and Indigenous Affairs, ex parte Lam, in the context of judicial review of executive decision-making fairness, it is essentially practical. Whether one talks in terms of procedural fairness or natural justice, the concern of law is to avoid practical injustice. There is no precedent that I was taken to in which any court has ordered a stay of or in a proceeding for defamation because of the impact of parliamentary privilege might have on the ability of one or more parties to pursue or defend the whole part of the proceeding. The Macquarie Dictionary really? The Macquarie Dictionary online defines the Australian colloquialism coward's castle as Parliament viewed as an arena in which statements are possibly libelous, can be made under protection of parliamentary privilege and therefore without fear of leaks. Major Adam, Major Rand, Mr. Olsen, Mr. Lewis, Mr. Wright, and Television New Zealand can be assumed to have been well aware of parliamentary privilege when each of them made a statement to Parliament or published it outside. The scenario in which Mr. Shanks finds himself is unlike that in Adam. In each of those three cases, the plaintiff politician had attacked the publisher or another person under parliamentary privilege and sued the defendant when he sought to refute the attack. Yet even so, in Ram, the majority, while holding the defence of justification would infringe S 16.3, could not be pleaded, did not stay the proceeding. Mr. Shanks and those assisting him prepared and chose those subjects of and statements in the Bros video. That publication appears to have been scripted and produced with considerable technical skills and support. Moreover, Mr. Shanks' solicitor, Mark Davis, deposed in explaining why his defence had not been filed in accordance with the rule that Christo Lanka is a producer and writer for Shanks' YouTube account called Friendlyjordies. He said Mr. Lanka had been responsible for much of the research that led to the preparation of both matters complained of, and those had voluminous underlying material. On the evidence, including, as viewing its contents reveals, the Bros video was not a spontaneous or unprepared publication. Mr. Shanks and those assisting him chose what he would say and do in the presiding Bros video. No doubt they had the opportunity to take legal advice, if they were so minded, as to what the consequences of publishing imputations 9b and c might be. Indeed, Mr. Shanks admits they were conveyed. He ensured that he conveyed those meanings by his own words in paragraphs 74, 77 and 78 of the Bros video. Namely, his assertion that Mr. Barilaro told the New South Wales Parliament under oath that he'd not given money to the Australia Oyster Coast because his friend ran it, and by doing so, he perjured himself 9 times over. You usually go to jail for committing perjury once. Relevantly, Mr. Shanks does not claim that this part of the Bros video came to be published because of any attack in or out of Parliament that Mr. Barilaro made on him. So do we get the feeling that if Bros had said something about Shanks, he actually under parliamentary privilege has the ability to attack? But because Shanks attacked something that he said in Parliament, you can't do it. Does that seem fair to you? As I explained, the common law and constitutional freedom of the Defamation Act allows members of the public, such as Mr. Shanks, the freedom to disseminate information, opinions and arguments concerning government and political matter, publish false statements under qualified privilege and express honest opinion on proper material or comment on facts stated in respect to what is said in Parliament. None of which would in fact infringe Art 9. That is, so even though Art 9 does not allow a defensive jurisdiction to be pleaded or advanced, the effect would be, as Mr. Shanks proposed defences to imputations 9 and C assert, to impeach or question what he said in Parliament by conveying that Mr. Barilaro committed perjury 9 times in what he told the committee. Here, Mr. Shanks chose to convey imputations 9b and c in an apparently prepared, researched and considered attack on Mr. Barilaro. I infer from the form of the defence that he did not choose or use language that would have allowed him to defend those imputations as a differently expressed publication might, under constitutional freedom, common law or statutory qualified privilege, or as honest opinion or fair comment on a matter of public interest. In those circumstances, it is difficult to see why it is unfair that Art 9 prevents him from proving the substantial truth of his choice, of what he said and how he said it. Rather, the unfairness lies in what Mr. Shanks seeks, namely to deprive Mr. Barilaro of the right to vindicate his reputation that Mr. Shanks attacked. It is Mr. Shanks's conduct unprovoked by Mr. Barilaro in doing what Art 9 prohibits from being justifiable, namely in the Bros video impeaching or questioning proceedings in Parliament, created his own difficulty in pleading the substantial truth of what he said. This has resulted in the situation which he finds himself there. So Justice Rare saying it's his own fault. Bros didn't attack him. He's just gone off on a rocker and gone off on his own and made these videos that said bad things about Bros, and Bros has got a hurt feeling now, and so now he's suing for defamation and is protected by parliamentary privilege. That's essentially the layman's terms. Possibly, because if the person's outside of Parliament, I think they can, because they're saying that it was unprovoked by Mr. Barilaro. So if you are provoked by a member of Parliament, so here is the thing. Shanks has to get Bros to talk about him in Parliament, and then he can attack. All right. Mr. Barilaro's right to pursue his admitted claim of the publication of the Bruz video conveying imputations on B&C cannot be characterised as an abusive process under R1621 or otherwise in the circumstances. Unlike Major Adam, Mr. Wright, Mr. Rand, Mr. Barilaro did not use parliamentary privilege to attack Mr. Shanks so as to provoke or entitle him to defend himself about allegations that his attacker had made under absolute privilege in proceedings in Parliament. I am of the opinion that Mr. Shanks's difficulty in pleading a defence to imputations 9B and C flows from his own decisions as to what and how he conveyed those defamatory meanings in the Bruz video. There we go. If a person publishes defamatory matter about what a member or another person said or did in proceedings in Parliament that the publisher cannot defend in a defamation action without infringing Art 9, ordinarily, the publisher should be in no different or better position than anyone whose act or admission creates liability for which the law does not afford a defence. In Preble, at 388DF, the Privy Council averted to a situation of unfairness in which, having attacked the publisher under parliamentary privilege, the plaintiff, as in right, effectively would have been able to recover damages, where the whole subject matter of the alleged libel relates to the plaintiff's conduct in the House. And Art 9 would exclude virtually all of the evidence to justify the libel. Of course, this is not the case because the Bruz video ranged far and wide in attacking Mr. Barilaro's reputation, as shown in 10 other imputations that both Mr. Barilaro and Shanks have pleaded. The critical factor to be borne in mind is that Art 9 creates a privilege of Parliament. This privilege is not that a member or other person who participates in proceedings in Parliament. The law cannot be that a publisher will be free to publish defamatory matter about what a member or other person who participates in proceedings in Parliament said or did, because Art 9 precludes a defence of justification. And the application of what the statutory prohibition creates an unfairness to the extent that the court will strike out or grant a stay of any defamation proceeding or part of it that the person whom the publisher attacked commences. Such a consequence would turn Art 9 on its head and instead create a privilege for the publisher to defame a member or other member who would lose any right to redress in accordance with the law just because what he or she said or did exercise in absolute privilege proceedings in Parliament. It would be an affront to justice if a publisher could choose to question or impeach proceedings in Parliament and by doing so create an effective immunity from suit by a member or person attacked. Such a result would convert Art 9 into an instrument of oppression. It would allow the publisher to be free to defame the member or other persons with impunity on the basis of any defence of the publisher's attack would infringe the prohibition of Art 9. That would leave the person defamed without remedy, and that every other individual is entitled to seek from the court, however well-founded, baseless attack. So he's saying that if he allowed parliamentary privilege to be waived, it would open the floodgates for anybody to publish anything that they liked about a politician. The common law statute and the constitutional freedom have effective mechanisms other than the defence of justification for the public scrutiny of words spoken and conduct engaged in during proceedings in Parliament. It'd be only beware all of the circumstances in which an actual or allegedly defamatory publication occurs left the publisher with no other bona fide defence than justification. And additionally, that there was some factor in the conduct of the plaintiff, such as him or her having used parliamentary privilege to attack the publisher or another, that made his or her use of defamation proceedings calculated to produce injustice or otherwise amount to an abusive process by the application that would warrant the court considering whether it was in the interests of justice to stay or grant a stay of proceedings or an aspect. So he's saying there, from my interpretation of that, is that if Bruz had actually attacked Shanks in Parliament, there may be a justification to stay the proceedings and strike it out because of the fact it comes under parliamentary privilege. So it says, I'm not satisfied that Mr. Barilaro's use of his own lawful right to sue Mr. Shanks for publishing imputations that he committed perjury 9 times. In addition, it should be jailed for doing so. on the material before me could render Mr. Barilaro's pursuit of a remedy in respect of those imputations and abusive process of the court. Accordingly, I refuse to stay the proceedings in relation to or strike out imputations 1B and C, or allow Mr. Shanks to file the defence in its current form, pleading justification and honest opinions as defences to these imputations. That is because those proposed defences are not justifiable. He would. It's very rare. You can, but you would again have to. You would have to have very good reason to. The only way to have another judge look at it would be to file an appeal. Mr. Barilaro argued that none of the particulars pleaded in support of the justification of it could establish its substantial truth, namely that he was a corrupt conman. He contended that the way in which the defence particularised the proper materials for the defences of honest opinion in respect to them was confusing and did not identify what particulars established the truth of any material. Mr. Barilaro submitted the contextual imputations, failed to articulate an act or condition that was defamatory of him. He argued that the imputations were informed to impressive and argumentative, and they did not make it clear the effective sting that Mr. Shanks needed to propound for them to be in the form appropriate to go to trial. Mr. Barilaro contended that even if Mr. Shanks made out his defences to remaining imputations and established substantial truths of his contextual imputations, none of them alone together or in any combination could possibly meet the test of S26B of the Act, because the subvening gravity of the imputations of serious perjury meriting imprisonment. Mr. Barilaro submitted that an absence of defence to imputations 9B and C, his cause of action is complete in respect of the Bruz video because Mr. Shanks admits that those imputations were conveyed and defamatory. Mr. Barilaro argued that the balance of the pleading defences were in fact not freestanding defences, but were matters going to mitigation of damages and must be pleaded as such. Mr. Shanks contended that none of Mr. Barilaro's complaints had merit. He submitted that the particulars were sufficient. He argued, did plead an act of conditions, and his written submissions and replies stated contextual truth. The contextual truth imputations were not deficient as alleged. The contextual implications alleged that the following defamatory acts or conditions against Mr. Barilaro, namely that he made an unwarranted attribution of blame, that he made a dishonest false accusation, that he made a decision that would cause others to think less of him, that he was a hypocrite, that he decided to adopt a course of action despite knowing the damage it would cause, that he failed to disclose relevant political donation when championing legislation, and that he breached his disclosure obligations as a Member of Parliament. Mr. Shanks contended that imputations 21A related to imputation 9A could be seen as the more serious, and that they were properly pleaded. He did not otherwise explain why. Now, we haven't seen any of these pleadings because we haven't been able to get hold of them. Mr. Shanks submitted that there was no requirement in S31 of the Act that proper material be specified or referred to in the matter complained of, or be notorious or generally known. He argued that it was sufficient if the proper material was notorious and that the ordinary reasonable viewer would understand that the publication complained of was conveying an opinion. He asserted that in any event, the defence sufficiently particularised the proper material on which he relied. So he's saying that everybody knew it was his opinion. Mr. Shanks contended that it would not be appropriate to strike out or refuse to allow him to rely on contextual imputations, since their potency and effect would only be assessed in light of evidence at the end of trial. Mr. Barilaro argued that Mr. Shanks should have pleaded all these facts to support his justification defence in respect of imputations. He did not seek that Mr. Shanks's defences to those two be struck out, however, for reasons I've given above, based on the prohibition of Art 9, the defences to 9B and C cannot be pleaded. Mr. Barilaro also sought that paragraph 19 of the defence be struck out, since the matters to which it relates to cannot be pleaded. Neither paragraph 19 of the defence nor Barilaro's complaints about the particulars for imputations on B and C are now relevant, because my findings on the application of Art 9 is not necessary to link them these reasons by discussing the questions. It is a lot to take in at once, isn't it? So now we're looking at particulars of justifications. So here's where you're talking about Port Barilaro. My name is John Barilaro. Call me Port Barilaro. I have no apology because at the end of the day, I'll stand up and fight for my community. The property of it with his wife. That's that one. Justification. So all the facts that they've used for that. The particulars of proper material for the Bros video. So they went and talked about what evidence that they've used. So, you know, the arts grant, the football club, the road upgrade, the bushfire, the Royal Commission, the wild horse. They've used that. I reject Mr. Barilaro's argument that none of the particulars above have capacity, if proved individually or in combination, to support the finding of substantial truth of imputation. The ordinary, reasonable viewer of the Bros video could understand what Mr. Shanks says at paragraphs 16 to 19 as an introduction to the new material. That will make it good his assertion that Mr. Barilaro is a con man to the core. The expression con man can be understood as a confidence. The improper use of ministerial power to benefit a political party or donor, such as suggested in the arts grant or wild horse particulars, is capable of being understood by the ordinary reasonable viewer as corrupt. Hello, Mimo. They were arguing, I mean, Bros was arguing that that the thing con man to the core meant that he was horrible, you know. I skimmed over the file. Hang on. Yes, they seem to think he's got a very weak argument. Although Poppy Seeds last night believes that Brothers was meritless, but, you know. But you've got to remember that Dr. Collins didn't come on late to the picture. So I think you'll find that his solicitors filed the defence. I think now that because Dr. Collins is a QC, I think now that the QC is on board and the defence will be rewritten, we're just talking about the court case that I attended. I think that now Mr. Collins now has to rewrite it all. I think it's going to be better. Immediately following Mr. Shake's statement, he's a comment to the core. He discussed the 2019-2020 bushfires. The bushfire particulars alleged that Mr. Barilaro caused the new NPWS not to be in the position to conduct hazard reduction burns and then blamed NPWS for not condoning such burns. In other words, Mr. Barilaro was seeking to blame deceptively or by conning the public NPWS for the bushfires when in fact his own conduct was responsible for NPWS's lack of action. The bushfires particulars giving support to the truth of contextual imputations appear to correspond roughly to statements in paragraphs 19 to 37 of the Bros video dealing with the funding for NPWS hazard reduction burns. Mr. Barilaro has been in London and his alleged statements relating to this general topic. Some of those particulars, however, such as A32, are so general as to be meaningless that states prior to bushfires, NPWS employees had warned publicly that because of the cuts, they did not have the funds or the staff to carry out their duties and had lost expertise in managing incidences. In contrast, paragraph 25 of the Bros video stated of NPWS, they'd been begging specifically, fat lips here, Mr. Barilaro, for the funds so that they could do hazard reduction burns. Here, noting in A32 is specific or supports the apparent statement of fact in paragraph 25 of the Bros video that NPWS had been begging specifically for the funds so that they could do hazard reduction burns. Rather, A32 asserts that an unspecified time prior to 2019-2020 bushfires, unspecified NPWS employees had made unspecified public warnings about not having funds or staff to carry out their duties. That vague collocation of generalised assertions does not give any particulars of when, how, or what was said. In particular, A32 does not allege what paragraph 25 of the Bros video asserts to as fact, namely that NPWS, not unnamed employees, had made specific requests for money to carry out hazard reduction burns. Thus, the bushfire particulars are inadequate to identify how Mr. Shanks seeks to establish that the substantial truth of what he published or of that act or allegation of being proper material. As I note below, there are some other problems with the particulars of proper material that equally apply to those particulars in respect to Mr. Shanks' reliance on them to support his plea of justification. So now we've got more court. He's got more stuff here. It's talking about the football club. So now it gets onto the secret dictatorship video. So that's something from his imputations there. So he says, I'm unable to follow how the chronology of A68 to 78 allows the drawing of the inference of the fact asserted in A79 that Ms. Cook acted on 27th of November 2018 with Mr. Barilaro's knowledge and impumata. Oh, thank you, Cal. To pressure the mayor to take action against Mr. Hall with the threat of withholding grant money. We've got that. So what he's saying there is that he's essentially gone through the transcript, and he's saying that some of the stuff that Shanks has said in those videos are based on, sources, unnamed sources, and using unnamed sources or generalized comments aren't substantial truths. So unless he named the person, so if he said person X at the NPWS said XYZ, it's substantial truth. But to say that somebody was complaining about it is not enough. That's essentially what he's saying, from what I can work out. So he's talking about why so now he's talking about the defective defense or the substantive defense issue, why it's defective, application of leave, deposed that Mr. Shanks published a YouTube entitled The Lawsuit Begins on the 31st of May, referring to Mr. Barilaro, in which he taunted, come on, you pussy, send it to me. And on June 4, he published another YouTube video titled Lawyer Calmly Dismembers Me, in which he said, we were waiting for around a week patiently thinking, yeah, any day now it will come. Okay, it's getting close to the end of the week and it's still not here. So we went over to the next week, still nothing. Mr. Shanks explained through Mr. Davis affidavit on 4th of June, the day after Shanks was served, Mr. Link had been arrested on 2 charges that he had stalked or intimidated Mr. Barilaro. Oh, now we're getting to the part. He was released that day on bail to appear in Newtown Court on the 24th of June. The bail conditions prohibited Mr. Lanka from, among other actions, first, possessing, sharing images or caricatures of Mr. Barilaro. Secondly, commenting on Mr. Barilaro's personal appearance or behaviour. Or thirdly, participating in the publishing of content further harassing Mr. Barilaro. Mr. Davies said that Mr. Lanka was particularly concerned about breaching the first and second of those conditions, and until the local court varied them on the 24th of June, had refrained from making essential inquiries of sources relevant to the preparation of Mr. Shanks's defence, or searching through his and Friendlyjordies' digital and paper records. Mr. Lanka engaged Mr. Davis's firm on the 7th of June. Mr. Shanks engaged it on the 14th of June. Mr. Davis said that he was acting for Mr. Lanka. He observed that the stress of his arrest and legal matters affected both Mr. Lanka and Mr. Shanks. Mr. Davis said that Mr. Lanka contacts, and general services did not become freely available to Mr. Shanks and his lawyers until the 24th of June, which until then had been substantially restricted the legal team's ability to obtain instructions. He said that about 1:49 p.m. on the 30th of June, when it appeared to be a real possibility that Mr. Shanks would not be able to file his defence by the 1st of July 2021, in accordance by R1632. The employed solicitor, Natalia Nicola, emailed Mr. Sylvan seeking an extension of time till the 7th of July. On the 1st of July, Mr. Sylvan spoke to Mr. Nicola and said that if Mr. Shanks wanted an indulgence, he would have to remove the Bruz video from YouTube. Isn't it blackmail? The parties subsequently engaged in much correspondence, including Mr. Shanks' solicitor letter of the 2nd July 2021 that misguidedly sought that Mr. Barilaro waive parliamentary privilege. As noted above, the defence was not lodged but accepted for filing and served at 4:30 p.m. on the 7th of July. So it was funny. So they went to the other side and said, can we file late? We're running out of time. We would like to have more time. And he said, well, you removed the Bruz video. We'll give you more time. While I accept that Mr. Shanks may have felt concerned for Mr. Lanka after his arrest, he gave no explanation at all for his delay of 11 days after he was served before instructing solicitors. Nonetheless, the overarching purpose of civil practice and procedure provisions in the Federal Court of Australia Act and rules is to facilitate the just resolution of disputes according to law and as quickly, inexpensively, and as efficiently as possible. Mr. Shanks did ultimately prepare and serve his defence nearly 1 week late, having made a mistake about the not necessarily straightforward way in which Art 9 may have affected his intention to plead his defences. However, for the reasons I have given, Mr. Shanks should not be permitted to file the defence as currently pleaded. In my opinion, it is in the interest of justice that Mr. Shanks be given an opportunity to plead it properly and file within 12 days a defence in accordance with these reasons. So he's saying what he has to take out. I do not intend that this opportunity will involve a wholesale reformulation or advancing of new defences. Mr. Shanks should be able to hold to the pleadings properly. If he can, no more than substantive case in the current but deficient version of defence. In light of his being in default and largely unsuccessful on the substantive matters argued, Mr. Shanks should pay Mr. Barilaro's costs of the leave application and strikeout application. I certify that the preceding 157 numbered paragraphs are true copy of the reasons for judgment by the Honourable Justice Reyes, August the 13th. And this is the transcript. So that's why he had to pay costs, because the justice deemed that he lost most of his matters. So then this is the pleadings. So he's got to the 25th of August to refile, and he's got to remove all of that sort of stuff. So he's got to, and yes, he's got to pay costs. So that was everything that happened in court today. Is everybody confused? Is everybody confused? Because that was pretty full on. I didn't realize how full on that was. So what we've learned is that a member of the public cannot hold a politician for account based on what they say in Parliament under parliamentary privilege. However, if a politician has a go at you as a member of the public in Parliament, you can then attack him. That's how I've interpreted that. Joe's watch and like count. What? Never updates while I'm here. Okay. The bias here reeks, says John Green. So that's what's happened. As I said, I think you'll find, because Matt Collins lectured on defamation law, Dr. Matt Collins, he he wrote a textbook on defamation law. And I think it was because he came on, they engaged him right at the lateness. That they had to accept the pleadings. He didn't have time to update the defense. So I think if now that they get a second chance at it, I think you'll find that it will be, I'm expecting it to be red hot. I agree, but I'm not saying it. Look, I have thought about taking the words out of Ralph, but I do always say that I am, I like it to be. The reason why I have it is because of Harrison, because he's the channel manager and he's nearly 10 years old. So, and he knows enough of those words. All right. So let's get to Katie Joy and Todd Chrisley. I did put, I know I sort of did some clickbait. I'm sorry, I shouldn't have done that. That was not very good of me. However, when somebody has said that they about suing you, what you don't do is you don't tell them to bring it on. Todd Chrisley claiming to have screenshots of me. We already know that my hate any lengths possibly to provide fake evidence and craft fake screenshots. My goodness, these people do not quit. So she's already starting to use that. Oh, my haters are fake screenshots. Girl, he went off for you and Lindsay. I'll never understand. Listen to him talk. It gave me a bad case of secondhand embarrassment. Where's the commentary on your best friend's court records dropped? Are those fake too? So that's all right. He responded, by the way. It's not very happy. Don't poke the bear. So then she says, Lindsay Chrisley put out the receipts. Lindsay provides evidence for the alleged sex tape extortion by Todd Chrisley and Chase Chrisley. So now she's showing all these. Now she's jumping in Lindsay's corner and saying, well, Lindsay's it's interesting because Lindsay says, I've been bullied online via Instagram, Twitter, and constantly. When I read that line, I thought, that sounds familiar. Listen to this. I've been bullied online via Instagram, Twitter, and constantly a topic of conversation on the podcast. That's her parents. But it's interesting how she talks about being bullied. Who else do we know? So this is what these are the screenshots she's now. The other thing is Todd the bear? I don't know what Todd is. So then it's got Lindsay Chrisley shares an affidavit from Robbie Haynes alleging that Chase Chrisley offered to pay him $15,000 for nude photos of her. Again, are these real or not? I don't know. I'm not really going there. Oh, yes, Todd Chrisley's the bear. Sorry, Todd Chrisley's the bear, not her Todd. I thought you were talking about Todd. So this is Lindsay's, and then she says, I'm proud of you. Nah, she just didn't bother with me. Did you? Chaotic. No, she's not bothered me again. She got me about 100 subs, though. Every time I get stuck, I say she needs to call me out again. So anyway, and then she says, sorry, haters, I am not sitting for any depositions. No screenshots will be handed over. Todd Chrisley should worry about his indictment and the 30 years he's facing. For me, she should be, I didn't know you had a choice. Don't you get subpoenaed? Todd's money is long, honey. I would be scared. Then why is your Insta down? You must be scared. Todd Chrisley. Let's have a look at Todd Chrisley. That's all right. Here we go. He, I think it was replies, was it? You rang. The only difference here is that Katie Joy won't unspend me because we all know she can't pay poo without a GoFundMe. Start begging now or skip a mortgage payment because it's going to cost plenty. Let the games begin. It's laughable at how deranged this Katie Joy is, but let her keep talking. September 1st will be amazing, and then we'll be heading towards her direction for a depot. Regardless of how many times she says something doesn't make any of it true, but let her keep posting. Trash bag Katie Joy's ignorant, but will be sitting for depositions, and her attorney has already been informed of that and agreed today that we have the right to depose her. She's delusional and trying to control the narrative. He is not playing. He is not playing. Sometimes to get to the high road, you got to step on some trash. She knows what's coming, and I'm laughing about how delusional she is. Trust and believe her attorney is fully aware of how hard we are coming. Phone records don't lie. Someone's got the picture of her in the trash can. That is amazing. You'll buy one of those tickets? I think there'd be a few tickets. So, yes. So, they've been going backwards. He's been responding to all the stuff. So, she says she's not doing a deposition. He's saying she is. Then he's saying that they're coming for her. Oh, thank you, Gingerly. What does he actually want from her if not money? I don't know what he wants from her. Somebody has actually done someone has actually put his name on her silver thing from YouTube. Let's go to Reddit. Oh boy. I think he actually wants her to admit that it was Lindsay that fed her all the information. I think that's what he wants. Can back and forth with Todd said what she did with Salt Sea. She's out of it. I think she's out of her league. Oh yeah, so of course, the Reddit's got it here. So put that all in there. Yeah, right. See you, Cal. I know it's going to take a while. It's funny. I did the video today about what happened in court, and all day I was thinking of other things I could have said. It'll take me a while to digest it too. Defiant Katie's not looking too bright. That's about she's not sitting for any defamation. Just seeing what they've got on here. Then there was this. Was this? It's maybe. Oh yeah. So somebody shared what her net worth was without a crystal ball net worth. Let's share full image. Without the Crystal Balls, an American YouTube channel with over 171,000 subscribers. I think it's 176 now, isn't it? Net worth of Without the Crystal Balls channel through to August 12th, 2021 is 453,519. Videos on the channel are posted in the category of lifestyle. Oh, that's where I need to put them. I don't never know what to put mine on. I think I put mine under entertainment. And I've put a couple of them under educational. She is in court with Little Miss Noble. That is correct, Christine. That is correct. But see, what I'm saying, she's now saying that Todd Chrisley has used fake email accounts and everything. But what? Well, that's why she's trying to hold on to it. No, there's not a commentary option because I looked that because that's what I wanted. Commentary. That's why she's holding on to her. That's why she's holding on to so much of her. That's why she's going down with a fight because she doesn't want to lose that. Her local courthouse is going to get tired of seeing her. Oh, by the way, New South Wales has tightened their restrictions. Finally. It says, Gladys must have listened to state premiers. Good to hear of restrictions. Take care, bunker down, stay home. You'll get through this, New South Wales. There was a crisis state meeting today after the National Cabinet. All the state leaders in the National Cabinet apparently were tearing shreds off her, allegedly. No, and they now have a restriction limit, I believe, John. No, I believe that they've tightened them again. What were they? Yeah, COVID test payment. Oh, and they're also doing COVID test payments now. So, but tell me, why are the 15 cases in Victoria worse than the 345 cases in New South Wales? New South Wales doesn't have them. Your white wind whispers her local courthouse is going to get sick of her. She had to wait till she got... Well, I've been saying 400 the last couple of days. I probably will be right tomorrow. I'm still thinking that we'll be at least... I think we'll be in lockdown at least until the end of the month. That is what I'm thinking. That's just my opinion. People don't like you in it. Hello, Jean. How are you? Oh, I think so. This is the other thing I found interesting was for some reason my video, I need to go to show you her Instagram. For some reason my videos about Brittany performed terribly. So if you like this kind of content, please check out my latest video so I don't continue the subject. I haven't finished watching it yet, Mr. Obvious. I was somewhat busy, caught up with court today. I probably... So let's have a look at what she's up to on Instagram. Okay. Oh, no, that's what... She didn't wear that, did she? All right, so her first post of the day was... Apparently, it's really bad to be 23 and have 3 kids. Kendra Duggar turns 23. Hard to believe she's only 23. 3 kids in 4 years. From teen mum to adult in the snap. And then someone says, nothing wrong with that. I had 3 kids by the time I was 23 and I couldn't be happier. They're saying we'll be locked down until Christmas. Well, sorry to hear that. I know what that's like. We had eased restrictions around my birthday last year, so we were actually all right. See you, Kim. We were just coming out of restrictions, and I was actually able. We went and got KFC. We were allowed to meet so many people at a park, and there was my mum, dad, my brother, and my kids. And we we're outside. You're allowed to meet other people outside. We were outside, and we had KFC at the park. She said, Jill Rodriguez and her daughters go swimming. They don't look like they're going swimming. Can you imagine the drag and heaviness of trying to swim in skirts, shirts, and leggings? Swimming outfits like this are not safest, but modesty is Jill's obsession for the Rodriguez girls. Thank you, Jean. The thing is, it looks like they're just mucking around and jumping in the water at night, but apparently they're swimming. Because we have to pick on what people wear. Yes, there's KFC in Australia. Jamie Spears, so that's about this. That I'm not interested in that. No, I'm not that I'm not interested. Right, this is what she was wearing today, by the way. Getting a ton of questions about my tops this week. I did an end of summer splurge at Lulu's. I have a few boutiques that I consistently buy from. Lulu's, 313 Clothing, Goodnight, Macaroon are my top 3 that I buy from regularly. I have been really into the romantic look this summer, mixed with a little boho. I wouldn't say that was romantic. Each boutique has a different style. Amy's boutique is very boho. Lulu's offers a more form-fitting romantic. I did have to swim fully clothed in the pool. We had to learn how to do that. So if we fell in the water, we could save ourselves fully clothed. Lulu's offers more form-fitting romantic looks with lots of options for tanks and tees. Goodnight Macaroon is my go-to for oversized, chunky sweaters. This is not sponsored, but I wanted to share because some of the comments are filled with questions. Also, I get questions on makeup. My lip color in most videos lately is by Natasha Denone, Liquid Matte, color 25 Louise. The actual lip I wore today is Anastasia Beverly Hills, color Pure Hollywood. I've got a question to ask you. Does her lip look fat? Eyebrows, Brow Wiz by Anastasia Beverly Hills. The 24-hour brow setter by Benefit. Foundation Makeup Forever Ultra HD Bronzer, Benefit Shade Hula. Mascara, Benefit. Where am I? Liquid Roller Black, Powder, NARS Translucent Loose. Liquid Cranium by Natasha Denone, Too Faced Born This Way palette. That's her eyeshadow. That's everything. I stick to what I like and just change up lip color. I do mostly neutral for my eyes because I don't want to be over the top. Hope this helps. Yes, I know. There are those. And that's the necklace I think she was looking about the other day. But I saw that and I thought I thought that she looks like she's had Botox into it. Well, that was when I looked at that, I thought, gee, her bottom lip looks a lot fatter. Like, I'm not one to comment on looks. I really don't. As you know, I don't like doing it. But that just stood out to me. Unfortunately. So she's done that. That's her videos performed badly. So this is Lindsay. So she's had another go at the Lindsay Chrisley. She says, Todd Chrisley has constantly blamed Lindsay for his criminal indictment. However, the feds have not one time listed Lindsay in any document nor alleged she was a whistleblower. She's saying, Todd and Julie Chrisley are facing a 12-count indictment and 30 years in prison. They had court today. They have another hearing on October. Yeah, hi, Verdandra. Well, anyway, it turned out that the health department got everything wrong, so he's back with his dad, so he's happy. And he's got his Nintendo Switch early. Their criminal cases continues. They're innocent and proven guilty. Extortion is a felony. She likes saying that. But But what's really interesting is that Lindsay Crickley isn't following her, and I thought they were best friends. So, it says Todd needs to walk away and leave her alone, poor Lindsay. I can't believe a parent would do that to a child. Mm-hmm. Well, he will probably want suggestions for Switch games. Yeah, his mother had picked him up. They got all the way home, and then the message came through that it was a false alarm, so they went back again. So they were very upset. But he works in hotel quarantine, so my brother has to have a COVID test every single day. So it's not as if and don't forget, she also posted this essay too about Todd. Good luck in court tomorrow. It says they have a lot to work to do if they want to beat this case. The feds already said that they are not going to settle this case without prison time. And it says the anti-KJ community are falling like the anti-KJ community is falling for it. They are like sheets. I found this Todd C thing ridiculous. The anti-KJ cult have grasped onto it and are behaving like he's a saint. The fact he's facing charges, the charges he is, and how he publicly treated his daughter proves he's a nasty piece of work. And they really need to look what qualities they idolize in a person. So do they. It just shows how blinded they are by their theories and ideologies, fed to them by the same head trolls. They seemingly just run with whatever narrative of hate they are directed to without analysing information in front of them for themselves. TC is usually definitely using this as a deflection, and the anti-KJ top cult have fallen for a hook, line, and sinker. The anti-KJ cult. The fact that this person's mentioned head trolls means that they obviously watch Uni Rock. Oh dear. Someone says, look forward to your video covering his jail sentence. Karma is so pleasant. Well, that's right, Laura. What if that's a cult? Oh dear me. Oh, it's funny, isn't it? It's funny though, isn't it? You would think though, with her having to go to court over her harassment hearing, to say that oh, this has just been posted. So I know I watch and subscribe because of your content and brain, but your makeup is always hot. Like, I'm so impressed with your shadow and blending. She says, thank you. I have spent a lot of time perfecting my technique, so much so that when I first started, it took me forever to get my face on. My brows take the longest. She might need to give our pictures robes. Yes, she might need to. But I really would have thought with her having court to talk about harassment and talking about how she was scared, she would have actually she would not be trying to poke Todd Chrisley. But that would be me. So, unbelievable, hey? I haven't been able to get the details for it. Someone did say that they had it, but I haven't got it. And I don't know what time it is, but I think I need sleep. I was going to stay up and watch it, but I was going to stay up, but I think I'll just wait for the highlights. I'm sure that there'll be lots of people talking about it. So, yeah, it's very interesting. Oh, the UK. I'm to be honest. Oh, there you go. It says people are complaining about the UK government. Sounds like they sound like the New South Wales government. I'm to be honest. I'm sick of the UK too. I don't even live there. It's just that UK government sent a horrendously callous example of tolerating human suffering, even spinning as in some way admirable when it is morally and ethically bankrupt according to the benefits of human. The pandemic isn't over. The virus is still potential lethal. The UK says it's okay as long as it's business as usual. Is that what the UK is doing? That's what I'm saying, Jean. If she's trying to show that she's scared online, why on earth is she taunting everybody? I'm sorry, I have to vet. I'm confused and lost. I don't know. Am I in the anti-KJ cult or Steve's cult or just a troll? I don't know either. Yeah, guess what? You can pick. You can pick. Okay. Yes, it is. Only in Scotland it's still masks inside. Wow. So interestingly, the UK is having some huge issues then. So they should be really back in lockdown, right? It sounds like that they're on New South Wales. They're like New South Wales at the moment. Although New South Wales, I'm not free. I'm still wearing a mask. Although New Zealand's got a few cases itself. So let's have a look. COVID statistics. Let's have a look. I mean, I don't want to rain on anyone's parade, but I'm just saying it seems to be that we have the whole world seems to be suffering, and I don't think that anyone will never go into lockdown. Well, that's what they reckon is going to happen when we hit 80%. But if this keeps mutating, I don't know. Are still wearing masks. Cool. Let's have a look. I gotta do another church. I've got to record church tomorrow as well. And I've recorded a kids segment as well. Oh dear me, I'm just a big kid. All right. Well, US figures, because these are just flicking over now. So some of these I've got to go to yesterday's figures. India had another 774. So for Iran, 39,000. Indonesia, 30,000. Mexico, 24,000. Philippines, 13,000. I'm only looking at cases, not deaths at the moment. Malaysia, 21,000. 18,000 in Japan. 23,000 in Thailand. And I'm just looking at the big numbers. I'll have to go to yesterday's figures to get the rest. Singapore's had another 49. See Australia, 414. New Zealand's down here somewhere. On. Oh, Hong Kong had another 5. Every country in the world is dealing with it, except Vatican City. Where was New Zealand? Oh, New Zealand. Oh, they had one new one today. New Zealand's got 44 active cases. So we're just not hearing about New Zealand because we'd much rather talk about Dan Andrews. Yeah, the Lambada. The Lambada is actually worse than Delta, and that's out of Peru. Yeah, so the Lambada is the new one. Yeah, I don't like being around people. I don't like people. So if we go back to yesterday, so if anyone's interested, this is worldmeters.info coronavirus. So we'll go back to yesterday. So the US had 143,000 cases and 600 deaths. UK, 33,094 deaths. Wowzers. India, 40,000 cases, 500 deaths. Brazil, 35,000 cases, 975 deaths. Iran, 39,000 cases and 568 deaths. Princess Jax, I don't know how they're ignoring it. I just cannot believe it. But UK also means Scotland too, doesn't it? Is that all of, or is Scotland separate from the UK? Yeah, as far as statistics are concerned. And someone like for now, despite Boris, yeah. Wow. Philippines has 12,000 new cases. Bangladesh, 10,000. Pakistan, 4,000. Oh, okay. Yeah, I haven't seen Scotland in this list, so I just wondered whether they were part of the UK stats. Because it'd be interesting just to see how it all broke up. Myanmar had another 3,000. Myanmar's not doing very well. You know that they had another 3,000 cases and another 200 deaths. Wow. Look at this. If we go to active cases, Myanmar, 72,000 active cases. So let's look at active cases just to scare us a bit. US have got 6 million cases. UK has 1.3 million cases. 4.3 million deaths worldwide. Isn't that scary? Plan to create? Doesn't that just scare you? Canada's had another 2,000 cases. So that was yesterday because it's only just ticking over. Because it's just Friday morning now. These are Friday stats. Right, Russia, 800 deaths. Active cases, 6.4. Let's find Australia again. We write down the bottom. Canada. Yeah. I don't know how it gets into, I don't know how it's ordered. So Canada apparently has 14,000 cases, 212 are critical. That's the other interesting thing. So in the US, 17,000 people are critical. In India, 8,000. Just going to find Australia. In Croatia, we have 106. Wow, but summer and it's tourist seasons, master mandatory. No, hello, Melon. No, I live in Victoria. So Stay away from me. Don't blame you. South Korea has 25,000 active cases, 369 people critical, 6 new deaths. China has had another 99 new cases. Yeah, it keeps mutating, and that's the problem. And each one is worse than the previous one. So we've got 6,484 active. So Australia has got 6,484 active cases, and 67 are critical. Yeah, of course. Recovered here. There's newly recovered. So Australia. Oh, we don't have those stats. So in Fiji. Newly recovered 322. So Fiji's had 39,000 cases and 14,000 recovered. They've got 24 active cases and 40 serious. So what we can say, I guess what this shows is that every country has been affected by it in some way, every country in the world. And some are actually now struggling. Yeah, so New Zealand's got 44 active cases. If it's Delta, it'll be interesting to see what happens there. Cayman Islands have got 5 active cases. I can't see Antarctica, actually. I didn't see Antarctica. Vatican City is okay at the moment. Vatican City and Solomon Islands are okay at the moment by the looks of it. Marshall Islands. So the ones in green are the ones that are okay at the moment. Micronesia, St. Helena, Samoa, Marshall Islands, Solomon Island. That's where we need to go. Oh, I haven't looked at the weekly trends. Let's look at those. I didn't see Antarctica, but that's not to say they're not there. Cameroon, 73. They say you need to get about 80% for COVID to go back to some level. Well, that's what they're looking at here. So look at the weekly cases. Look at that. An increase of 180,000 from the 4 weeks. Increased. And then newly recovered. So weekly trends. Oh, yeah, look at that. Oh, really? See you, John. Well, they haven't even got Moderna. It's only been given provisional license. They're still doing trials. So America has had an increase of 23%. Yeah, look, your UK plus 9% over the week. All you need is one person. All you need is one person to have that variant, and you're gone. And some of them have got are going down. Well, Peru's had a drop. Mawali, Australia has had an increase of 43%. Yeah, population 25 million. What, we've done 4 million. We've just hit 4 million. I thought I was the only one. I'm going crazy about people. No. I had my first face-to-face class 2 weeks ago for university, and I was a wreck. I was an absolute wreck. And I came home and I had to sleep, and I decided I didn't want to go back to university again. That's what I decided. I didn't want to go around people again. I just don't like it. I just don't like being around lots of people. So anyway, on that note, I'm going to call it a night. I thank you for joining me. It was a bit of a brain drain going through the judgment today for Barilaro and Shanks. I hope that I've tried to explain it a little bit as to why and how it's all happened. I hope it was exciting. I hope it was interesting for all the overseas people, particularly when you find out that you can be protected. Politicians are protected by parliamentary privilege. It's a very interesting concept. Yeah, so I hope you've got an insight as to how our federal court works. I got an insight as to how the federal court works in the Westbrook Paulson matter, but we'll see how it works in the Chrisley Paulson matter, and it'll be interesting to see what happens with Little Miss Noble. If Katie Joy wins, we'll hear all about it. If she doesn't, we won't hear a word. Do you think that that's correct? Because she was bragging how she had a temporary 2-year restraining order. Well, if she loses tomorrow, she's got nothing. So all that bragging for nothing. Oh, wow. Yeah, I don't like crowds. I'm not a crowds person. I don't like being around big groups of people. I've never liked it, but I think COVID's just helped me realize how much I don't like it. Yeah. All right, well, I'll catch you all tomorrow, and we will probably discuss the Paulson Little Miss Noble matter. I guess we'll know that at some stage. And, yeah, I'll catch you all later. All right, make sure you hit like and subscribe and all of that jazz, and all that jazz. I'll catch you later.